Dear students, I welcome you to yet another lecture on corporate law. The topic of discussion for today's lecture is the Takeover Code. That is, the Securities and Exchange Board of India's Substantial Acquisition of Shares and Takeover Regulations 2011. The genesis of the Takeover Code in India began with the Securities and Exchange Board of India Act 1992. That is SEBI Act 1992. Under the Act, SEBI had the mandate to regulate substantial acquisition of shares and takeovers by suitable measures. Consequently, SEBI provided a legal framework by enacting the Takeover Regulations 1994, which came into force on November 4, 1994. In November 1995, a committee was appointed by the SEBI to review the Takeover Regulations 1994 under the chairmanship of Justice P.N. Bhagwati, which was also called the Bhagwati Committee. The said committee submitted its report in January 1997. Taking into consideration its recommendations, the Substantial Acquisition of Shares and Takeover Regulations 1997, referred to as the 1997 Code, was notified by SEBI on February 20, 1997, repealing the Takeover Regulations of 1994. The 1997 Code was amended from time to time to keep pace with the developments in the marketplace, regulatory and judicial rulings, as well as evolving global practices. A committee was reconstituted under the chairmanship of Justice P.N. Bhagwati in 2001, which was tasked to conduct a review of the 1997 Code. The reconstituted Bhagwati Committee submitted its report in May 2002. Based on the same, further amendments were made to the 1997 Code. The increasing level of mergers and acquisition activity in India, the growing sophistication of the takeover market, and various judicial pronouncements contributed to the necessity to review the 1997 Code. Accordingly, SEBI, via its order dated September 4, 2009, constituted the Takeover Regulations Advisory Committee, TRAC, under the chairmanship of Mr. C. Achuthan, with the mandate to examine and review the 1997 Code and to suggest suitable amendments as deemed fit. Based on the recommendations made by the Takeover Regulations Advisory Committee, SEBI brought into effect the Takeover Code, repealing the 1997 Code with effect from October 23, 2011. The code is applicable only to listed companies. With the introduction of the Takeover Code, SEBI has completely overhauled the takeover regime in India and has rewritten the rules of public mergers and acquisitions. In comparison to the 1997 Code, the Takeover Code offers a much simpler, precise, and unambiguous regulatory regime. While the basic premise of the 1997 Code has been retained under the Takeover Code, the TRAC has also analyzed the international best practices, jurisprudence laid down by the courts and tribunals over the years, and the changing needs of the market to propose a new set of takeover regulations. SEBI included most of the recommendations made by the TRAC in the Takeover Code and has attempted to strike a balance between the interest of the various stakeholders, including the acquirers, the shareholders, and the target company. The overarching philosophy of protecting the interest of the public shareholders in takeover situations remains intact even under the Takeover Code, but other critical changes have been introduced. Dear students, we now try and understand the rationale of the Takeover Code. The guiding principle of the Takeover Code is the protection of the interest of the public shareholders of a company. The public shareholders do not generally participate in the affairs of the company and therefore rely on the promoters or controlling shareholders to manage the company in their best interests and the highest standards of corporate governance. Therefore, the change in shareholding, voting rights or control of the target company will have an impact on the interest of the public shareholders. It is necessary that target company and the shareholders are not taken by surprise by the shareholding or voting rights of an acquirer and the persons acting in concert. Further, the acquisition of shares or voting rights and the price of such acquisition are relevant for determining the minimum of a price for an open offer. This underscores the significance of disclosure obligations of an acquirer or shareholder under the Takeover Code. The dealings in shares of a listed company need to be transparent to keep the shareholders informed of the changes in shareholding or voting rights in a company, and also to insulate the security market from financial volatility. It is also important to note that disclosure obligations apply to acquisition of both shares and convertible securities. Dear students, now let us look at some important definitions under the Substantial Acquisition of Shares and Takeover Regulations 2011. The first definition is takeovers and substantial acquisition of shares. When an acquirer takes over the control of the target company, it is termed as takeover. When an acquirer acquires substantial quantity of shares or voting rights of the target company, it results into substantial acquisition of shares. Acquirer. Acquirer means any person who, whether by himself or through or with persons acting in concert with him, directly or indirectly acquires or agrees to acquire shares or voting rights in or control over a target company. An acquirer can be a natural person, a corporate entity, or any other legal entity. The next definition is persons acting in concert, or PAC. Persons acting in concert are individual or individuals, company or companies, or any other legal entity or entities who, with a common objective or purpose of acquisition of shares or voting rights in or exercise of control over the target company, pursuant to an agreement or understanding, formal or informal, directly or indirectly cooperate for acquisition of shares or voting rights in or exercise of control over the target company. The SAST regulations 2011 define various categories of persons who are deemed to be acting in concert with other persons in the same category unless the contrary is established. The next definition is that of a target company. The company or body corporate or corporation whose equity shares are listed in a stock exchange and in which a change of shareholding or control is proposed by an acquirer is referred to as the target company. Open offer. An open offer is an offer made by the acquirer to the shareholders of the target company, inviting them to tender their shares in the target company at a particular price. The primary purpose of an open offer is to provide an exit option to the shareholders of the target company on account of the change in control or substantial acquisition of shares occurring in the target company. Globally, the focal point of jurisprudence of takeover regulations is to offer an exit opportunity to the public or minority shareholders of a company in the event of any substantial change in shareholding or change in control of the company. Equity demands that the public stakeholders who have invested in the company, relying on the management or promoters of the company, are given an opportunity to withdraw their investments when there is a change in the management or promoter shareholding. Therefore, the Takeover Code casts a duty on an acquirer whose acquisition fulfills the prescribed conditions to make a mandatory offer to acquire shares from the existing shareholders of the target company prior to consummating his acquisition. To safeguard the economic interest of the exiting shareholders, it is provided that the mandatory open offer should be at the best possible terms for the shareholders. It is for this reason that the terms of the mandatory offer, including timing, price discovery mechanism, minimum offer size, etc., are prescribed under the Takeover Code. While the mandatory open offer is an important legal obligation, the Takeover Code also permits voluntary open offers at the absolute option of the acquirer. Mandatory open offer triggers. If an acquirer has agreed to acquire or acquired control over a target company or shares or voting rights in a target company which would be in excess of the threshold limits, then the acquirer is required to make an open offer to the shareholders of the target company. The threshold limits for acquisition of shares or voting rights beyond which an obligation to make an open offer is triggered. Number 1, acquisition of 25% or more shares or voting rights. An acquirer who, along with the persons acting in concert, if any, holds less than 25% shares or voting rights in a target company and agrees to acquire shares or acquire shares which, along with his persons acting in concert, existing shareholding would entitle him to exercise 25% or more shares or voting rights in a target company, will need to make an open offer before acquiring such additional shares. Number 2, acquisition of more than 5% shares or voting rights in a financial year. An acquirer who, along with persons acting in concert, if any, holds 25% or more, but less than the maximum permissible non-public shareholding, which is 75%, in a target company, can acquire additional shares in the target company as would entitle him to exercise more than 5% of the voting rights in any financial year only after making an open offer. Acquisition of additional shares or voting rights entitling the acquirer and the persons acting in concert to exercise more than 5% of voting rights in a financial year by any acquirer who, together with the persons acting in concert, already holds 25% or more but less than 75% of the capital in the target company, or acquisition of control over the target company. Dear students, we now discuss voluntary open offers. A voluntary open offer under Regulation 6 is an offer made by a person who himself or through persons acting in concert, if any, holds 25% or more shares or voting rights in the target company but less than the maximum permissible non-public shareholding limit. The acquirer is required to make a voluntary open offer for at least such a number of shares as would entitle the acquirer to exercise an additional 10% of the total shares of the target company. Restrictions on acquirers making a voluntary open offer. A voluntary offer cannot be made if the acquirer or persons acting in concert with him has acquired any shares of the target company in the 52 weeks prior to the voluntary offer. The acquirer is prohibited from acquiring any shares during the offer period other than those acquired in the open offer. The acquirer is also not entitled to acquire any shares for a period of 6 months after the completion of the open offer except pursuant to another voluntary open offer. Dear students, we now discuss the voluntary offer by a person holding less than 25% of the voting rights or shares in a target company. Any person holding less than 25% of the shares or voting rights in a target company is also entitled to make an open offer voluntarily. This open offer should be for a minimum of 26% of the share capital of the target company, as opposed to 10% as permitted under Regulation 6. Dear students, we now look at the points of distinction between the voluntary offer made by a person holding less than 25% of the shares or voting rights in a target company and the voluntary offer made by a person holding more than 25% of the shares or voting rights of the target company. Voluntary offer by a person holding less than 25% of shares. In such a case, the minimum offer size has to be 26%. Voluntary offer by a person holding more than 25% of shares. In this case, the minimum offer size has to be 10%. Maximum can be for the entire share capital of the target company. In the other case, the maximum offer size is linked to the maximum permissible non-public shareholding permitted under the Securities Contracts Regulation Rules 1957, which amounts to 75% of the shareholding. Dear students, we now look at the competitive offer. A competitive offer is an offer made by a person other than the acquirer who has made the first public announcement. A competitive offer shall be made within 15 working days of the date of the detailed public statement made by the acquirer who has made the first public announcement. If there is a competitive offer, the acquirer who has made the original public announcement can revise the terms of his open offer provided the revised terms are favorable to the shareholders of the target company. Further, the bidders are entitled to make revision in the offer price up to 3 working days prior to the opening of the offer. The schedule of activities and the offer opening and closing of all competing offers shall be carried out with identical timelines. Dear students, we now discuss conditional offer. An offer in which the acquirer has stipulated a minimum level of acceptance is known as a conditional offer. Minimum level of acceptance implies minimum number of shares which the acquirer desires under the said conditional offer. If the number of shares validly tendered in the conditional offer are less than the minimum level of acceptance stipulated by the acquirer, then the acquirer is not bound to accept any shares under the offer. Dear students, we now look at certain exemptions provided by the Takeover Code. In respect of certain acquisitions, the Substantial Acquisition of Shares Regulations 2011 provide exemption from the requirement of making an open offer subject to certain conditions being fulfilled. Some of these are: number 1, acquisitions pursuant to interseat transfer of shares among qualifying persons. The qualifying persons are A. Immediate relatives, B. Promoters holding shares for at least a period of 3 years prior to the proposed acquisition, C. A company, its subsidiaries, its holding company, other subsidiaries of such holding companies, persons holding not less than 50% of the equity shares of such company, other companies in which such persons hold not less than 50% of the equity shares, and their subsidiaries subject to control over such qualifying persons being exclusively held by the same persons. D. Persons acting in concert for not less than 3 years prior to the proposed acquisition. Number 2. Acquisition in the ordinary course of business by an underwriter registered with SEBI, a stockbroker registered with SEBI, a merchant banker registered with SEBI, a scheduled commercial bank acting as an escrow agent, a scheduled commercial bank or a public financial institution such as a pledgee, a registered market maker of a stock exchange, and any person acquiring shares pursuant to a scheme of safety net under the ICDR regulations are exempt from open offer obligations subject to certain prescribed conditions. Number 3. The acquisition of shares of a target company under the corporate debt restructuring scheme notified by the Reserve Bank of India in 2001, which is approved by the shareholders and which does not amount to a change in the control, is also exempt from open offer obligations. Number 4. Acquisitions pursuant to the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002, that is the SARFESI Act. B. Pursuant to the provisions of the delisting regulations. C. By way of transmission, succession or inheritance. And D. Of voting rights or preference shares carrying voting rights arising out of the operation of subsection 2 of section 87 of the Companies Act. As per the provisions of the Companies Act, where public companies are concerned, preference shares have no voting rights as are accorded to equity shareholders. This is the case except where dividend has not been paid by such company when due on the preference shares for 2 years. In such a case, preference shareholders are entitled to vote at par with equity shareholders. Number 4. Acquisition of shares in a target company from a venture capital fund or a foreign venture capital investor registered with the board by promoters of the target company pursuant to an agreement between such venture capital fund or foreign venture capital investor and such promoters. Number 5. Acquisition pursuant to a scheme made under Section 18 of the Sikh Industrial Companies Special Provisions Act 1985 or any statutory modification or reenactment to it. Dear students, we now look at SEBI's power to grant exception. In the interest of the securities market, upon an application made by the acquirer, SEBI has the power to grant exemption from the requirements of making an open offer or grant a relaxation from strict compliance with prescribed provisions of the open offer process. Before undertaking such acquisition, SEBI may at its discretion refer the application to a panel of experts constituted by SEBI. The orders passed in such matters would be uploaded on SEBI's website. Dear students, this is all with regard to today's lecture on the Takeover Code. In today's lecture, we try to understand the meaning of an open offer, a mandatory open offer, a voluntary open offer. We also discuss a competitive offer and a conditional offer. Dear students, with this we wrap up today's lecture. Hope you enjoyed the lecture. Stay blessed.